What are the pros and cons of filing a petition for non-parent custody in juvenile court versus district court? Attorney Kelly Peterson explains that. The advantages for filing in juvenile court is that juvenile court judges are much more accustomed to terminating parental rights than are district court judges. The other potential advantage to being in juvenile court is that the juvenile court's judge may rope in the Division of Child and Family Services or a guardian ad litem, an attorney for the child. That can be an advantage, and it can also be a disadvantage. It can be an advantage essentially if DCFS and the guardian ad litem supports your petition. Sometimes DCFS or the guardian ad litem will file motions or gather evidence for the court that you would normally have to do on your own. The problem is, if they believe that someone else should have custody, then they'll be actively working against your petition, and you won't know very often going in advance which is the way they're going to go. Another distinct disadvantage to filing a petition in juvenile court is that the juvenile court judge is likely to appoint a court-appointed attorney to the parents. If the DCFS or a guardian ad litem opposes the petition, that would be detrimental. The court can also appoint an attorney to represent the parent at no cost, while you are required to pay for your own attorney. However, in district court, the judge will not appoint a free attorney to the parents, and it may be an advantage or that the DCFS or a guardian ad litem is not involved, competing with your petition. If you file in district court, it's unlikely that those two entities would be involved, which if a petitioner wishes to minimize the number of surprises in their case, they might consider advantageous. The other advantage is that for petitions that's filed in district court, the court will not appoint an attorney to the other side, to the parent. Why not? Because the government is not an actor. It's not the government bringing the petition. It's not the DCFS and the Attorney General's office filing a petition. If it was the government, then likely the court would have to appoint a court-appointed attorney to the indigent respondent. But in district, always a private party that brings the petition, and there is no statute allowing for a court-appointed attorney because there is no right to counsel in a civil case where the government is not an actor. For a free phone consultation, call Attorney Kelly Peterson in Provo, Utah today. The areas of family law are complex and ever-changing. Kelly Peterson has extensive experience and expertise practicing as a family law attorney in a variety of areas.